There we go. Should be hearing me now. There we go. That's better. Okay. Welcome. Sorry about that. A little bit of a glitch. We're here tonight for the regular Resolute, the disability and employment law. I call it different things. I guess tonight we'll call it the law hour. I'm probably going to be here an hour or less tonight. We're going to do a little bit of a shorter show because I have some work I have to finish up tonight. Didn't want to cancel outright, though, because some people did submit in some questions, so we want to get to those. I'm David Brannen. I'm the owner of Resolute Employment and Disability Lawyers. Please, as you're watching, you can go ahead and just type in your questions. This is a Q&A, so I will go through some questions that people have sent in ahead of time, but I'm also happy to answer questions for people that are here. So let's take a look at our first question. Let's go take a look here. This one came in, I think it came in last week. This is one that we get a lot. Someone had written in wanting to know if their situation was that they were on long-term disability and the insurance company required them to apply for CPP disability. They applied, they got denied, and then they didn't do anything else after that, and the insurance company just started deducting an amount of money from their benefit, even though they weren't getting CPP disability. So first of all, that person had a number of questions. They wanted to know, first of all, were they legally required to apply for CPP disability, as the insurance company had asserted they were? The answer to that is probably yes. Again, you can't really know for certain what you're required to do in a long-term disability situation unless you actually unless someone actually looks at your insurance policy, your particular insurance policy, to see what it says that you're required to do. There are some insurance policies that do not require you to apply for CPP disability, nor do they deduct CPP disability. So whereas there are others that do require you to apply for CPP disability, and if you fail to apply, or if you apply and don't appeal, they have the right to estimate and deduct the benefit they think you should be getting. Now, that's what was happening with this individual. Their insurer was estimating and deducting what they thought this person should be getting for their CPP disability. Now, there is something that goes along with the insurance companies doing this estimating and deducting. What they will usually do is say, we will waive our right to estimate and deduct your long-term disability benefits if you sign this document, which is called, the Irrevocable Consent to Deduct and Pay. This is a form that was created by Service Canada for CPP disability. It was created to set up a situation where an insurance company can have one of their insured people sign this form. This form then directs Service Canada and CPP disability to deduct and pay them directly once your CPP disability is approved. So the insurance companies want this because it guarantees they get the money once your CPP is approved. Otherwise, if they don't have something like this in place, you would get approved, the money would go to you. If you choose not to pay the money over to the long-term disability that's owed to them as an overpayment because of your CPP approval, then the insurance company, it makes it more difficult for them and for you as well. The insurance company may have to deduct or lessen the amount of LTD benefits you have. They may bring a lawsuit against you to collect back the money that's owed from the overpayment. There's all kinds of things that can happen. That's why it's valuable to the insurance company to have people sign this irrevocable consent to deduct and pay. It's a form that you will usually be given by the insurance company as part of their agreement that if you sign this form and apply for CPP disability, they will not start estimating deducting your benefit. All right. Okay, we have a question already. Let's have a look-see. This one says, I'm planning on applying for CPP and initial application, and I am currently on LTD just over 11 months. My insurer has not yet asked to apply, but I know medical condition is not improving. Okay, so that's good that your insurer hasn't pushed this on you yet. They probably will bring it up at some point, but there's nothing stopping you from applying at any time. The only thing I would consider is like, where is your doctor on this? Sometimes doctors are reluctant to help people. They'll allow you to, like, doctors will support you with your long-term disability because they know it's preventing you from just doing your regular job. CPP disability is really making a statement that you're incapable of any substantially gainful employment, not just your regular work that you do. And doctors are reluctant. Sometimes doctors will think it's even more severe of a disability than even that. So doctors can be reluctant to fill out CPP disability applications when someone is still in the active treatment phases in the year or so after being off on disability leave. Now, if your doctor is supportive, there's no reason you couldn't start applying for CPP disability at any time. Okay, this one, there's a follow-up here. It says, I have not tried any return to work or any job, but my history of injury was from 2019 to 2025. Slip and falls made it completely difficult to engage in any work that you would suggest. Any work that you would suggest on this, David? Well, you don't necessarily have to try to return to work. It is certainly helpful if you've tried to return to work for CPP disability purposes, but again, it's only reasonable to do that if you have an ability to do work, or that you might possibly have the ability to do some type of work. But when in doubt, I do encourage people to try to return to work in some capacity. but you don't have to. Like, it will depend. It looks like your LTD will cover you for 2 years probably while you're unable to do your own job, and then after that, the LTD insurer may they may take the view that you could go do other types of work. So this is just something that you would need to work out with your doctor in your situation to determine if there is any other type of work that you might be able to do. And it is better to try things rather than it's always better to try, at least from Service Canada's point of view. When they're looking at CPP disability claims, it's easier to get the claim approved if you can demonstrate that you have actually tried to go back to do some other work. Now, it depends on your education level and the type of work you were doing before, but there may be obvious other types of jobs that you could do that would be seen as easier. And if you haven't tried those, then it can be difficult for you to convince Service Canada that you would not be able to do them. Okay. Here's one closely related to what you just said. Some people want to know that will applying, like if they're being forced to apply for CPP disability by the insurer, but they don't really want to, they do want to try to return to work in the future. Can applying for CPP disability hurt your chances of returning to work? The answer to that is no. Applying for CPP disability on its own will not prevent you from returning to your former employer or to any other employment. You would simply just have to, if you do get to go back to work, you just would dismiss or withdraw your CPP disability claim, and it would not, you could then apply again in the future. If your disability came back worse, you could apply again in the future. So there's no downside. Like, it's not preventing you from returning to work or, from returning to work. Certainly, even CPP disability has a vocational rehabilitation program where they specifically help people return to work. So if you did get approved for CPP disability, even then you still can try to return to work, and they have specific programs to help people do that. Okay, so this is one I kind of already addressed this. What happens to my LTD if I apply for CPP disability and then don't follow up with appeals? Well, what can happen, again, we'd have to read your policy to see exactly how it's worded, but potentially what can happen is if your policy requires you to do not just apply, but to also do appeals, which some of them do, then failing to do the appeals would put you in a situation where your insurer may be legally able to estimate what you would be getting from CPP disability and then deducting it. It's a very harsh kind of outcome. Normally, the insurers will not do this if you are in the process of actively appealing your CPP disability claim. But certainly, if you do not actively appeal your CPP disability claim, your insurer may be able to just estimate and deduct the benefit. So what this puts you in a spot is where you're getting a reduced LTD benefit, but you are not receiving the CPP disability benefit that they are estimating that you would get. This creates a bad situation because if you later decide to apply for the CPP disability benefit, it can only go back a year maximum from the date of your application. So you can find yourself in a situation where you won't get reimbursed all the money that's been deducted out of your LTD. Normally, if they're estimating and deducting, and then you subsequently get approved for CPP disability, you get to keep the back pay from the CPP disability because they've already, in a sense, deducted out that money. There's no overpayment. There often has to be a reconciliation. So maybe they've deducted too much and you get some money back, or maybe they didn't deduct enough and you might owe slightly more. But the reality is like they've already accounted for that money. But if they've been deducting CPP, estimating deducting your CPP for over a year from the time you apply, you will not get it all back because the CPP retroactive payment can only go back a year from the date of your application. All right, let's shift gears a little bit. We had a question this week. This wasn't so much a question. This is something I've talked with a couple of clients this week explaining why it is that employers, if you're in a wrongful termination situation, why is it that some employers, even when you have a lawyer representing you, will still give what would be considered low ball? That means very low, like lower than your legal rights would require, or the legal requirements would require, low offers. So they're offering to pay severance that is much less than you would legally be required. And why would employers do that, even though you have a lawyer? The answer to this is that some lawyers bluff, and people making claims for wrongful termination are bluffing, meaning that they hire a lawyer to write a letter to the employer demanding payment, but some employers will just see that as an empty threat and don't believe that you will actually go ahead with suing them or filing a human rights complaint. So they will just continue to make lowball offers, very low offers. Like we had a case where they're offering like $8,000 and we're at $80,000, right? So we're literally like $72,000 apart. They will continue to do that because it works in some cases. In some cases, the client only wanted to hire the lawyer to write a letter or only to try to negotiate before filing a lawsuit. And then the client would then determine that they don't want to go forward with a lawsuit. And so they end up dropping the case or just accepting the lowball offer. I've had this discussion 2 or 3 times this week with different clients. And the reality is that is a thing, and it works. I've certainly had clients where they had the option to go forward with a lawsuit. I mostly work actually for litigation, I only work on contingency fee. So clients have the ability to move forward with a lawsuit without having to come up with more money as a retainer or paying as they go type of thing. It's easier for them to do so. But even in that case, some clients they can't deal. They want it over, and they don't want to have this in their life to be dealing with on an ongoing basis. And so they will take a lowball offer. It does work, unfortunately. Some clients will choose, works in the sense that some clients will end up taking the low offer because that's a better result for them than the fear of going through a lawsuit and having this drag out further. So I've had a couple clients this week where I've had this conversation with them. One of them had a fairly high offer, but like a 6-figure offer, but it's still, in the scheme of things, it's still a low offer compared to what he is entitled to for a wrongful termination. And so part of my conversation with that person was, okay, like you can't have everything you want. Like you can't have a settlement that happens before a lawsuit is filed and get a good amount of money. Okay. It's very hard to do. It's very hard to do that. The only way to do that is if there are some extreme situation where there could be some big embarrassment for the employer, like a big embarrassment for the employer for some reason, that they would rather pay the premium to get it done now rather than drag you out. There's a greater advantage to employers to dragging things out because the longer the case goes, usually the better for them, meaning that you might go back to work in the meantime and that will reduce what they have to pay you. You may get frustrated and just want to drop the case after a while because it is stressful dealing with long-term litigation that is ongoing. And so many employers will try to drag that out. But unfortunately, what you can't have is like get a good deal in terms of good compensation for what you're probably legally owed and have it done early. Okay. That usually is not two things that go together. And so I'm often in a situation where I have to advise clients like, look, you have 2 options. Like you can take 3 options. You can drop the case. You can take what they're offering now before we file the lawsuit, or we file the lawsuit and you see how things shake out. Some employers, it is a game of chicken. And as soon as you file the lawsuit, now all of a sudden they're ready to negotiate and come to the table with more money. However, that's not always the case. Some employers will dig in even further. I don't know if any of you watched the TV show The Landman, but you see the lawyers on there dealing with that oil company, that lawyers with oil companies and big corporations. It's a little bit hyperbolic what you see on Landman, but it's not completely untrue how some of them act. And I've represented a lot of clients against large corporations, including oil companies, and they can be some of the worst to deal with. And so some of them, they will offer you money before the lawsuit is filed. And they basically say, look, this is what we're offering. And then if you don't take that, they will then fight you out tooth and nail right to the steps of court and possibly make you go through a trial before agreeing to pay you anything else. They want to be known as that it's torture and hell to be able to get money from them. Some of the banks are taking this approach. Some of the major banks no longer will negotiate anything before a lawsuit is filed, right? And some of them have taken the same kind of hard-nosed approach that some of the oil companies have, and they either will offer something early or they will just outright refuse and force you to go the whole way to a trial in order to try to get money. They do this in order to discourage other people from bringing a similar claim, because they will see you complaining about it, or the lawyers will tell people. Like, I have to tell people now with banks that a lot of the banks now are taking a scorched earth type approach. So if they've accused you of some wrongdoing, even if it's untrue, but they believe they have a chance of proving it, it's a scorched earth, and they may just force you to go the whole way to trial. So I'm telling that to potential clients, and that is discouraging people from even going forward with cases, right? So it's the intended effect. All right. Okay, this question says, sorry, let me get back to it. This one says, I was told I would receive a letter coming with a request to apply for CPP, but nothing in the mail to date. Once received, how much time is acceptable for an approval before reducing CPP? Okay, so first of all, just follow up with the insurer to see if it got lost in the mail or whatever. Most insurers, as long as you are making a good faith effort to do the application and move it through the appeals process, they will not estimate and deduct your payments. However, if things are dragging out, you're not responding to them, then that is when they could just come down hard, or you refuse to sign all the forms that they want, any of those kind of scenarios, and they could start estimating and deducting. Okay. And they can give you very short notice that they're going to do that. But if they see that you sign all the paperwork they want, like that irrevocable direction to pay form that I was talking about, you sign other things that they want, and you are demonstrating to them that you're acting in a diligent, good faith way to get this claim forward for CPP disability, most of them will not start estimating and deducting. They use that as more of a punishment to step in if people are dragging their feet, refusing to sign forms, and this kind of thing. All right, so this also comes up quite a bit. Sometimes, especially the type of cases I do for wrongful dismissal, I do a lot of, my specialty is doing wrongful dismissal cases that involve sick leave, disability leave, people who have been discriminated in the workplace because of disability or illness or sickness, this kind of thing. And so a question that comes up is, what do you do? Like, if you've been wrongfully terminated and it involves workplace discrimination, how do you do that? Do you have to file 2 lawsuits? Do you have to go through a human rights complaint? Like, how does it work? Now, the way that I handle it is, if my client has the possibility of both types of claims, so they are very different types of claims. Wrongful termination, wrongful dismissal is a claim that you bring through the regular court system. It is a common law type of action, and that's basically what it is. It's a common law action through the court system for wrongful dismissal. Okay, it's just like filing any other lawsuit for breach of contract. However, most, with the exception of Ontario, you cannot file lawsuits for human rights complaints in Canada. Those types of complaints have to go before the human rights commissions, in tribunals. Each province has its own human rights commission and tribunal, and you would need to file your claim through that tribunal, not through the courts. Now, one exception is Ontario, where if there is an intermingled wrongful dismissal human rights claim, you can file it all through the court in one jurisdiction, which makes it a lot easier. But in other provinces, what I would do in these cases is I just file both. We would file the lawsuit for wrongful dismissal, and at the same time, we file the human rights complaint, so that you have both options open. The reason we do that is they are separate damages. So you can't get the human rights damages in most courts in Canada, but you can get them through the Human Rights Commission. Now, it is difficult to have two parallel proceedings going on at the same time. So often the human rights claim will be suspended pending the outcome of the trial, and that is something that can happen. Now, when you're negotiating with the employer for severance, you're negotiating on both of those claims, and any agreement, any settlement would involve you dismissing or withdrawing both claims, the lawsuit for wrongful dismissal and the human rights complaint for human rights damages. Okay, this one says, I was disabled already as per a functional capacity evaluation and independent medical assessment reports, examination reports from heavy duty like warehousing job. I am currently work from home job, which is sedentary and it's extremely difficult to engage in. Okay, well, that would be the kind of thing that people would, if you're demonstrating and trying to do a work from home job that is sedentary and you move from doing a warehousing type job, then you are doing a very good job. And you should make sure that it's well documented with your doctor how you're doing. But that is the kind of thing that Service Canada would want to see, and also your insurance company. Now, the things you'd want to look for there is how much you can earn working from home. Maybe you won't earn enough that you may still be able to do that part-time and still qualify for long-term disability. But generally speaking, if you're able to do that work, you likely would not qualify for CPP disability based on the low amount that you're allowed to earn before you no longer qualify for CPP disability. Great questions, folks. Great questions. Okay. That brings me to the end of the stuff the things that people had submitted in and that I had grabbed off of our internal questions this week. Let me just see. Yeah, I had a couple more, but I think that's where I'll end it there and see if people have other questions. I do apologize for the short segment here tonight, but I do have to finish writing a CPP Disability Tribunal brief. I wasn't able to finish it up today, so I have to finish it up this evening. But if I do have time, if anyone has one final question, if not, save your question for next week. You can send it to us at support@resolutelegal.ca. and just indicate that it's a question for the weekly YouTube live. And I certainly can answer that. All right. Well, that's all for tonight. I will see you folks back here next week. Hopefully things will start to settle down for me. We have another lawyer starting in the firm on February 2nd. So it'll be, when new lawyers start, it's usually busier for me and getting them up and going. But once this person gets up and going, it'll take a lot off of my plate that I'm dealing with right now. So it's one of the things with law firms, they kind of grow and sometimes they contract, but we're kind of in a growth phase right now. And so it can be stressful in terms of in between trying to get staffed up with the right amount of lawyers for the number of clients. Anyway, folks, we will see you back here next week. I do wish you all the best. Take care.